Away from that, judges hearing the 2020 election petition have set Thursday, February 11, to rule on whether Chair of the Electoral Commission, Jean Mensa, must be cross-examined. This was after lawyers for 2020 NDC presidential candidate insisted as a public officer who supervised elections and served notice of testifying in court, the EC chair cannot back out at this stage. Lawyers for the EC had earlier informed the Supreme Court the EC chair will not be called into the box. Court correspondent Joseph Akable was in court and filed this report.
Lead counsel for the Electoral Commission, Justin Amenuvo, had already indicated to the court that he will be making a request that the Electoral Commission chairperson is given the leeway not to enter the witness box to be cross-examined by lawyers for the petitioner. And he did justify that in his own view by insisting that the settled case law points to the fact that the Electoral Commission chairperson and any witness for that matter cannot be compelled to give evidence in any case.
Also, it's my submission that Rule 3E, all the provisions are quite very clear, and my learned friends putting one interpretation on it on one day and another interpretation on it on another day is most unfortunate. Respectfully submitted.
Mr. Kotompa, who represents President Akufo-Addo's team, agreed with this view and advanced arguments to back the view on why they also have the right not to call Peter McMenu into the box to be cross-examined.
Society of Lloyds versus Sir William Otho Jeffrey BT 2000 EWHC Commercial 51, where the issue of a party failing or refusing to give evidence after a witness statement had been served on other parties in the suit arose, and a prayer was made for the witness to be compelled to enter the box. The court held as follows: where a party, after serving a statement of his witness on the opposing party in accordance with pre-trial directions, decided not to call that witness to give evidence, the court had no power to order that party to call its witness to give evidence in court. Unquote.
Lead counsel for President Mahama Chachuchikata, however, disagreed.
Shall call is mandatory, the last time I checked in the law books. And my lords, I'm sorry.
The lie, as you read.
Yes, but my lords, as that now, nobody has said we don't intend to rely on the witness statement. Nowhere has it been stated. All they have said is that we are not doing. My lord, that is the reality. I mean, however much grumbling goes on the other side, my lord, this is important because there are many options open to us. If they say they are not relying on the witness, we can apply to the court for a subpoena to call the chairperson. For instance, we can apply to the court. Yes, because
I thought it is implied.
My lord, the only reason why we did not take that course is, of course, because she is acting on behalf of the first respondent.
The court adjourned proceedings to Thursday to deliver its ruling. The two legal teams disagree on the quality of the arguments that have been advanced by their respective sides.
It's curious that the petitioner, on whom the burden of proof lies, wants the Electoral Commissioner to mount the witness box in order for him to use the Electoral Commissioner to prove its case. This is not heard of, and our application today was firmly grounded in law. Lawyers, when we go to court, decide the strategy we want to take. We, as counsel for the second respondent, decided to take this course of action.
There is evidence on record showing that she had elected to give evidence and to be cross-examined on the witness statement that she has filed. Now, we will not go into the merits or demerits of what she has filed because the court is yet to give its ruling on that on Thursday. But suffice it to say that the reason why we are insisting that she be allowed to testify is simply because My brothers and sisters, this is not a debt collection case. We are not here dealing with a private matter, the private interest of private litigants. We are here dealing with the public interest. We are here dealing with the declaration of the results that reflected or is supposed to have reflected the sovereign will of the people of this country.
On Thursday, the issue for determination will be whether or not an individual who has filed a witness statement and indicated to the court that he intends to testify can change his or her mind and decide not to testify any longer and be subjected to cross-examination. Reporting for JoyNews from the Supreme Court, my name is Joseph Akable.
And that's how we end the AM News with me, Mapito CBD.